Good morning. Today we are going to see a case law on Arbitration and Conciliation Act. This is reported in AAR 2022 SC 2673 BBR India versus SP Singla Construction. An interesting question came up for consideration by the Supreme Court. The facts of the case: X and Y entered into a contract. Letter of intent issued under contract contained an arbitration clause for resolution of disputes by sole arbitrator. Arbitration clause was silent on the seat and venue of arbitration. This is very important. Contract and letter of intent were executed in Panchkula, Haryana. Dispute arose between the parties. Matter was referred to single arbitrator as per the agreement. Single arbitrator decided venue of proceedings, please note, venue of proceedings would be Panchkula, Haryana. After the pleadings were completed, arbitrator, for some personal reason, he recused himself. I will not enter into this arbitration. He went away. New arbitrator entered and fixed the venue of proceedings as Delhi. Earlier arbitrator fixed the venue of proceedings as Panchkula, Haryana. New arbitrator fixed the venue of proceedings as Delhi. Award was pronounced. It was in favor of Y. Now, two proceedings were initiated against order, one by X and other by Y. X challenged the award before the Delhi High Court. Y filed an application under Section 9 of Arbitration Act for interim orders before the additional district judge. The additional district judge, Panchkula, dismissed the application for interim orders on the ground of lack of jurisdiction. He held that jurisdiction lies only before Delhi High Court, as Section 34 appeal filed by X was prior in time. This was challenged before the Punjab High Court by Y. Punjab High Court held that the courts of Delhi do not have jurisdiction, as the agreement was silent about seat of arbitration, and the second arbitrator did not decide Delhi as seat of arbitration. First arbitrator also did not decide the seat. He said venue of proceedings. Second arbitrator also said venue of proceedings, but he said Delhi as seat of arbitration. So the decision of Punjab High Court was challenged before Supreme Court. Question before Supreme Court was, which court has jurisdiction? Whether Punjab and Haryana or Delhi. In the present case, the arbitration proceedings were held in two places. First in Panchkula, Haryana, and then in Delhi. That we have seen. But the first arbitrator, by its order, decided that the place of proceedings would be Panchkula. Once the arbitrator fixes the seat, in terms of Section 22 of the Act, the arbitrator cannot change the seat except when parties agree and state that the seat of arbitration should be changed to another location. This is what Supreme Court says. Party freedom is important. That is why parties can agree and change. The arbitrator cannot change. The seat once fixed by the arbitral tribunal should remain static, whereas the venue can be changed. That is what the Supreme Court says. The contention, the courts where arbitration proceedings are being conducted should be given supervisory powers, was also rejected by the Supreme Court. Another contention, that substantive proceedings were held in Delhi and therefore it would be the seat of arbitration. This was canvassed by Y. The proceedings before first arbitrator were only filing of pleadings and documents, whereas the actual proceeding took place in Delhi. So Delhi courts must be held to have jurisdiction. It was also rejected by the Supreme Court on the ground of confusion and uncertainty. Supreme Court held, when the question of jurisdiction arises, the place or venue fixed for arbitration proceedings will be the jurisdictional seat, and the courts having jurisdiction over the jurisdictional seat would have exclusive jurisdiction. This principle would have exception only when by mutual consent of parties jurisdictional seat is changed. Such a consent must be expressed and clearly understood and agreed by the parties. Otherwise, no. Supreme Court held the fastest finger first principle cannot apply. X pleaded that he first filed Section 34 appeal before Delhi. Hence, Delhi court must be held to be having jurisdiction. Supreme Court said no. In this case, as a seat of arbitration is already fixed as Panchakula, that is Haryana, and hence Delhi court have no jurisdiction. This is the interesting case law of the Supreme Court. Thank you very much. Have a great day.